Please subscribe, like and share this content. It means a lot to us. Thank you in advance. Cornell Law School. U.C.C. Article 3, Negotiable Instruments. Part 3, Enforcement of Instruments. Paragraph 307. Notice of breach of fiduciary duty. Primary tabs A in this section. 1. Fiduciary means an agent, trustee, partner, corporate officer or director, or other representative owing a fiduciary duty with respect to an instrument. 2. Represented person means the principal, beneficiary, partnership, corporation, or other person to whom the duty stated in paragraph 1 is owed. B. If an instrument is taken from a fiduciary for payment or collection or for value. 2. The taker has knowledge of the fiduciary status of the fiduciary. And 3. The represented person makes a claim to the instrument or its proceeds on the basis that the transaction of the fiduciary is a breach of fiduciary duty. The following rules apply. 1. Notice of breach of fiduciary duty by the fiduciary is notice of the claim of the represented person. 2. In the case of an instrument payable to the represented person or the fiduciary as such, the taker has notice of the breach of fiduciary duty if the instrument is taken in payment of or as security for a debt known by the taker to be the personal debt of the fiduciary. 2. Taken in a transaction known by the taker to be for the personal benefit of the fiduciary. Or 3. Deposited to an account other than an account of the fiduciary, as such, or an account of the represented person. 3. If an instrument is issued by the represented person or the fiduciary as such, and made payable to the fiduciary personally, the taker does not have notice of the breach of fiduciary duty unless the taker knows of the breach of fiduciary duty. 4. If an instrument is issued by the represented person or the fiduciary as such, to the taker as payee, the taker has notice of the breach of fiduciary duty if the instrument is taken in payment of or as security for a debt known by the taker to be the personal debt of the fiduciary. 2. Taken in a transaction known by the taker to be for the personal benefit of the fiduciary. Or 3. Deposited to an account other than an account of the fiduciary, as such, or an account of the represented person. Paragraph 308. Proof of signatures and status as holder in due course. Primary tabs A in an action with respect to an instrument, the authenticity of, and authority to make, each signature on the instrument is admitted unless specifically denied in the pleadings. If the validity of a signature is denied in the pleadings, the burden of establishing validity is on the person claiming validity, but the signature is presumed to be authentic and authorized unless the action is to enforce the liability of the purported signer and the signer is dead or incompetent at the time of trial of the issue of validity of the signature. If an action to enforce the instrument is brought against a person as the undisclosed principal of a person who signed the instrument as a party to the instrument, the plaintiff has the burden of establishing that the defendant is liable on the instrument as a represented person under Section 3402A. B. If the validity of signatures is admitted or proved and there is compliance with subsection A, a plaintiff producing the instrument is entitled to payment if the plaintiff proves entitlement to enforce the instrument under Section 3301, unless the defendant proves a defense or claim in recoupment. If a defense or claim in recoupment is proved, the right to payment of the plaintiff is subject to the defense or claim, except to the extent the plaintiff proves that the plaintiff has rights of a holder in due course which are not subject to the defense or claim. Paragraph 309. Enforcement of lost, destroyed, or stolen instrument. Primary tabs A person not in possession of an instrument is entitled to enforce the instrument if 1. The person seeking to enforce the instrument A was entitled to enforce the instrument when loss of possession occurred, or B. has directly or indirectly acquired ownership of the instrument from a person who was entitled to enforce the instrument when loss of possession occurred. 2. The loss of possession was not the result of a transfer by the person or lawful seizure, and 3. The person cannot reasonably obtain possession of the instrument because the instrument was destroyed, its whereabouts cannot be determined, or it is in the wrongful possession of an unknown person or a person that cannot be found or is not amenable to service of process. B. A person seeking enforcement of an instrument under subsection A must prove the terms of the instrument and the person's right to enforce the instrument. If that proof is made, Section 308 applies to the case as if the person seeking enforcement had produced the instrument. The court may not enter judgment in favor of the person seeking enforcement unless it finds that the person required to pay the instrument is adequately protected against loss that might occur by reason of a claim by another person to enforce the instrument. Adequate protection may be provided by any reasonable means. Paragraph 310. Effective instrument on obligation for which taken. Primary tabs A. Unless otherwise agreed, if a certified check, cashier's check, or teller's check is taken for an obligation, the obligation is discharged to the same extent discharge would result if an amount of money equal to the amount of the instrument were taken in payment of the obligation. Discharge of the obligation does not affect any liability that the obliger may have as an endorser of the instrument. B. Unless otherwise agreed and except as provided in subsection A, if a note or an uncertified check is taken for an obligation, the obligation is suspended to the same extent the obligation would be discharged if an amount of money equal to the amount of the instrument were taken. And the following rules apply. 1. In the case of an uncertified check, suspension of the obligation continues until dishonor of the check or until it is paid or certified. Payment or certification of the check results in discharge of the obligation to the extent of the amount of the check. 2. In the case of a note, suspension of the obligation continues until dishonor of the note or until it is paid. Payment of the note results in discharge of the obligation to the extent of the payment. 3. Except as provided in paragraph 4, if the check or note is dishonored and the obligee of the obligation for which the instrument was taken is the person entitled to enforce the instrument, the obligee may enforce either the instrument or the obligation. In the case of an instrument of a third person which is negotiated to the obligee by the obliger, discharge of the obliger on the instrument also discharges the obligation. 4. If the person entitled to enforce the instrument taken for an obligation is a person other than the obligee may not enforce the obligation to the extent the obligation is suspended. If the obligee is the person entitled to enforce the instrument but no longer has possession of it because it was lost, stolen, or destroyed, the obligation may not be enforced to the extent of the amount payable on the instrument, and to that extent the obligee's rights against the obliger are limited to enforcement of the instrument. C. If an instrument other than one described in subsection A or B is taken for an obligation, the effect is I that stated in subsection A if the instrument is one on which a bank is liable as maker or acceptor, or 2 that stated in subsection B in any other case. Paragraph 311. Accord and satisfaction by use of instrument. Primary tabs A. If a person against whom a claim is asserted proves that I, that person in good faith tendered an instrument to the claimant as full satisfaction of the claim. 2. The amount of the claim was unliquidated or subject to a bona fide dispute. And 3. The claimant obtained payment of the instrument. The following subsections apply. B. Unless subsection C applies, the claim is discharged if the person against whom the claim is asserted proves that the instrument or an accompanying written communication contained a conspicuous statement to the effect that the instrument was tendered as full satisfaction of the claim. C. Subject to subsection D, a claim is not discharged under subsection B if either of the following applies. 1. The claimant, if an organization, proves that I, within a reasonable time before the tender, the claimant sent a conspicuous statement to the person against whom the claim is asserted that communications concerning disputed debts, including an instrument tendered as full satisfaction of a debt, are to be sent to a designated person, office, or place, and 2. The instrument or accompanying communication was not received by the designated person, office, or place. 2. The claimant, whether or not an organization, proves that within 90 days after payment of the instrument, the claimant tendered repayment of the amount of the instrument to the person against whom the claim is asserted. This paragraph does not apply if the claimant is an organization that sent a statement complying with paragraph 1(I). D. A claim is discharged if the person against whom the claim is asserted proves that within a reasonable time before collection of the instrument was initiated, the claimant, or an agent of the claimant having direct responsibility with respect to the disputed obligation, knew that the instrument was tendered in full satisfaction of the claim. And Sect. 312. Lost, destroyed, or stolen cashier's check, teller's check, or certified check. Primary tabs A in this section. 1. Check means a cashier's check, teller's check, or certified check. 2. Claimant means a person who claims the right to receive the amount of a cashier's check, teller's check, or certified check that was lost, destroyed, or stolen. 3. Declaration of loss means a statement, made in a record under penalty of perjury, to the effect that I, the declarer, lost possession of a check. 2. The declarer is the drawer or payee of the check in the case of a certified check, or the remitter or payee of the check in the case of a cashier's check or teller's check. 3. The loss of possession was not the result of a transfer by the declarer or lawful seizure, and IV. The declarer cannot reasonably obtain possession of the check because the check was destroyed, its whereabouts cannot be determined, or it is in the wrongful possession of an unknown person or a person that cannot be found or is not amenable to service of process. 4. Obligated bank means the issuer of a cashier's check or teller's check or the acceptor of a certified check. B. A claimant may assert a claim to the amount of a check by a communication to the obligated bank describing the check with reasonable certainty and requesting payment of the amount of the check, if I, the claimant, is the drawer or payee of a certified check, or the remitter or payee of a cashier's check or teller's check. 2. The communication contains or is accompanied by a declaration of loss of the claimant with respect to the check. 3. The communication is received at a time and in a manner affording the bank a reasonable time to act on it before the check is paid, and IV. The claimant provides reasonable identification if requested by the obligated bank. Delivery of a declaration of loss is a warranty of the truth of the statements made in the declaration. If a claim is asserted in compliance with this subsection, the following rules apply. 1. The claim becomes enforceable at the later of I, the time the claim is asserted, or 2. The 90th day following the date of the check, in the case of a cashier's check or teller's check, or the 90th day following the date of the acceptance, in the case of a certified check. 2. Until the claim becomes enforceable, it has no legal effect and the obligated bank may pay the check or, in the case of a teller's check, may permit the drawee to pay the check. Payment to a person entitled to enforce the check discharges all liability of the obligated bank with respect to the check. 3. If the claim becomes enforceable before the check is presented for payment, the obligated bank is not obliged to pay the check. 4. When the claim becomes enforceable, the obligated bank becomes obliged to pay the amount of the check to the claimant if payment of the check has not been made to a person entitled to enforce the check. Subject to Section 4302(a)(1), payment to the claimant discharges all liability of the obligated bank with respect to the check. C. If the obligated bank pays the amount of a check to a claimant under subsection B(4) and the check is presented for payment by a person having rights of a holder in due course, the claimant is obliged to I. Refund the payment to the obligated bank if the check is paid, or 2. Pay the amount of the check to the person having rights of a holder in due course if the check is dishonored. D. If a claimant has the right to assert a claim under subsection B and is also a person entitled to enforce a cashier's check, teller's check, or certified check which is lost, destroyed, or stolen, the claimant may assert rights with respect to the check either under this section or Section 3309.